Hi and welcome. This week I plan to talk about justice in general, and in particular, Rudy Giuliani's First Amendment defense to the charge that he helped incite a violent insurrection. As far as the justice issue, I get a lot of comments and questions like these on social media. Republicans seem to have a penchant for just saying whatever. No fact-checking or accountability. No consequences. Bald-faced lies are the norm. This is the fallout from Trump getting away with everything he did. The longer this goes on, the worse it will be. And how long does justice take? We all saw this play out. Facts are known. A generation has watched Trump lie and con with no consequences. Where is the justice? There are a few misconceptions contained in these questions. The first is that our political problems are the result of the wheels of justice moving slowly. The second is that the criminal justice system, or the civil justice system, is the solution to a major political problem. Now, I'm going to ask you to bear with me while I do a deep dive into Rudy Giuliani's First Amendment defense to the charge that he contributed to inciting the January 6th insurrection. As a bonus, this legal discussion will help you prepare for the First Amendment portion of the YouTube bar exam, which I will be administering at the conclusion of this video series. Take notes and you'll be ready. Okay, so at the conclusion of former President Donald Trump's second impeachment trial, Senate Minority Leader Mitch McConnell concluded that Trump was practically and morally responsible for provoking the insurrection of January 6th. He also said that the people who stormed the building believed they were acting on Trump's wishes and instructions. McConnell justified his vote to acquit by punting responsibility to the courts, saying the courts were a more appropriate venue for holding Trump accountable. McConnell was wrong about the Senate's role. The Senate was an appropriate venue for holding Trump accountable. That's why the Constitution gave Congress that power through the impeachment and removal process. McConnell was punting responsibility and ducking the issue. He was kicking the problem down the road. Brings us to this week. The House passed a bill to create an independent, bipartisan commission to investigate the January 6th riot. But lots of Republicans are trying to prevent such a commission from forming. Well, we all know from the decades-long investigations into the Clintons that the Republicans are not opposed to commissions and investigations as a matter of principle. Well, fortunately, we have three branches of government. So if one branch engages in corruption, there are two other branches that can investigate and expose the truth. One branch, of course, is the executive branch, which fortunately is not controlled by Republicans right now. What the executive branch at the Department of Justice is doing is investigating the insurrection as a crime. Already, 494 people have been criminally charged for their part in the insurrection. This is moving very fast for a major crime. Criminal investigations do take time, and the way prosecutors and investigators work is they start with the foot soldiers and work their way up to the generals, because it's always easier to arrest and prosecute the actual insurrectionists because we have pictures of them committing crimes. Higher up, people manipulating them have more deniability, which we will see when we get to Giuliani's First Amendment defense. Of course, the third branch is the judicial branch. Representative Eric Swalwell of California, among others, took McConnell at his word. In March, Swalwell filed a lawsuit against Trump and his alleged co-conspirators, Donald Trump Jr., Representative Mo Brooks, and Rudy Giuliani. Swalwell was terrorized by the attack and harmed by the riot. He alleges that the defendants' actions and speeches taken together were responsible for the violence that ensued at the Capitol. This week, Rudy Giuliani filed a motion to dismiss the lawsuit against him. A motion to dismiss basically says they have no case. Throw the whole thing out before wasting this court's time. In his motion to dismiss, Giuliani presents a First Amendment defense, claiming that everything he said was protected speech. Okay, this is a civil case, but it's the same defense we can expect to see in criminal prosecutions, because it's the best defense they have. Okay, so first a few key facts as they pertain to Rudy Giuliani. These facts are taken from Giuliani's own brief. On January 6th, we know, was the day that Congress was set to count the electoral votes and certify the election, which means declaring Biden the winner and the president. One bit of law everyone seems to agree on is that once the election is certified by Congress, Trump could not enter the White House. Biden would be the president and reside in the White House. On that day, the 6th, Trump held a rally called Stop the Steal. The rally was held in Washington, D.C., down Pennsylvania Avenue, and it was scheduled for shortly before Congress was set to count the votes and certify the election. Lots of congressional Republicans encouraged their supporters to attend. That evening, before the riot, Giuliani tweeted a link to a YouTube video entitled, "Watch This Before January 6th." The video falsely claimed that it was legal for Vice President Pence to block the counting of the votes and block the certification of the election. Giuliani retweeted the post later that night and the following morning just before the rally. During his speech at the rally, Giuliani again repeated these false claims. Specifically, he said, "It is perfectly appropriate, given the questionable constitutionality of the Election Counting Act, that the vice president can set it aside." What Giuliani told the crowd was not true. Pence did not have the authority to set the law aside and not certify the election. Giuliani then went on to tell the crowd exactly what he wanted. He wanted 10 days to take the matter back to the states, which he said would give him time to prove that the election had been rigged. He then went on about how the Democrats rigged the election. He talked about the fraud he would find if he had the 10 days. Now, he also told the demonstrators, "We will have trial by combat." Then he said this: "This has been a year in which they have invaded our freedom of speech, our freedom of religion, our freedom to move, our freedom to live. I'll be darned if they're going to take away our free and fair vote. And we're going to fight to the end to make sure that doesn't happen." He concluded by urging the crowd to have the courage it takes to later be able to say, "I'm doing the best thing for myself, for my family, for my children, and most importantly, for the United States of America." Now, Giuliani, of course, never explained how he expected Congress to be stopped from certifying the election, other than repeating this false claim that Pence had the power to stop it, which, of course, riled up the crowd against Pence. Now, unless I'm missing something, given the fact that Congress was clearly set to certify the election, and Pence correctly said he didn't have the power to stop it, and moreover, he wasn't going to try, the only possible way to stop the certification was through intimidation. But notice, Giuliani never actually said that. But what we can see is exactly what Giuliani and his co-defendants did. They called together a large crowd, they riled them up, they told them this lie about Pence, and then at the end, Giuliani stood by as Trump told the rallygoers to fight like hell and march down Pennsylvania Avenue to the Capitol. Giuliani's defense is that he used phrases like trial by combat in the context of finding voter fraud after being given to take the matter back to the states. He said in his motion to dismiss that no reasonable person would think that trial by combat meant trial by combat on January 6th. Now let's look at what the law says. The law says that speech is protected unless it is directed at inciting or producing imminent lawless action, and that it was likely to incite or produce such action. This rule comes from a Supreme Court case called Brandenburg versus Ohio. Clarence Brandenburg was a Ku Klux Klan leader. He's the guy here in the sheet standing with his friend Richard Hanna. So Brandenburg was arrested and charged after addressing a small crowd in Ohio. He bemoaned the fate of the white Caucasian race and alluded to the possibility of what he called revengeance in the event that the federal government and courts continued to, quote, suppress the white Caucasian race. The Supreme Court held that his speech was protected because it was not directed at inciting or producing imminent lawless action and was not likely to incite or produce such action. Now, why is this a good ruling? Because we don't want to be able to haul people off to jail for saying things we don't like. Think about how that could be weaponized against you. Lack of freedom of speech and lack of protections is exactly how autocrats imprison political opponents. So the way legal analysis is done is we take the law, which is, were the words directed at inciting lawless action, and we apply the facts to see if, in fact, the words violate the law. So you're thinking, but these guys, including Giuliani, did rile these guys up, and the rioters did immediately walk over to the Capitol and commit violent crimes. I mean, after all, does Rudy Giuliani expect the court to believe it was pure coincidence that the rioters did exactly what he wanted them to do? Does he expect the court to be surprised that the rioters proceeded using the only methods they had available, attempting to intimidate Congress into abandoning the counting of the votes. Well, it does seem like it shouldn't be too difficult for the plaintiffs to prove that Giuliani was part of a conspiracy to direct or encourage the rally-goers to interfere with the counting of the votes and the certifying of the election. I mean, again, the only way to interpret the title of the rally, Stop the Steal, was that they wanted to stop the counting and stop certification of the election. I mean, why else did the defendants plan the rally for the day and time Congress planned to certify the election? Why else did they rile up the crowd, tell them it was legal to stop this, and then point them to the Capitol after explaining why the certification had to be stopped? I mean, why else did Giuliani repeatedly assure the crowd that Pence had the power to stop the process? Okay, and how did Giuliani think that this particular crowd was supposed to pressure Pence? Now, Giuliani may have couched his language a bit. After all, he's a lawyer, but the rioters got the message. They got the message that it was up to them to prevent the election from being certified. Giuliani writes in his motion that there is no plausible way to construe his speech before January 6th Capitol insurrection as inciting clear and present danger of violent mob action. And this is where Giuliani gets the law wrong. To lose his First Amendment protection, his speech must simply incite a lawlessness or illegal behavior. He doesn't have to have intended to incite a violent mob insurrection. This is a subtle but important point, because Giuliani can point to his speech and everything he said and make a case that he in no way urged the kind of violence that erupted. But the legal question isn't whether he intended or directed violence. The legal question is whether he intended to incite lawlessness. As it turns out, we have a law that specifically makes it illegal for two or more people to conspire to interfere with an official's duties by means of threat or intimidation. No coincidence, this is what he's being charged with in this lawsuit. So if Giuliani and his co-defendants intended for the crowd to stop the counting of the votes and the certifying election, and if there's really no other way for them to do this without resorting to threats or intimidation, it would certainly seem that Giuliani was inciting imminent lawlessness. So really, all the plaintiffs have to do is show that he urged the crowd to stop the counting of the votes and that he had good reason to know that the only way this crowd could do that was through intimidations or threats. This is a picture from the Brooks Brothers riot in Florida during the 2000 elections. I suspect what Giuliani and his defendants were hoping for was a replay of that particular riot. This was when rioters, orchestrated by the Bush campaign, intimidated the Florida vote counters into stopping their work. This delayed the certification of Florida's election, which then gave the Supreme Court time to step in and call off the recount. If this was Giuliani's goal, it would be unlawful. Now, I think he can prove that he never directed or intended to direct all the violence which occurred during the insurrection. That's what makes this tricky. What I want you to see is that sometimes legal issues aren't quite as easy and straightforward as we think. It's easy to shake our fist and say, we all heard Giuliani say trial by combat, but the law doesn't work that way. And his defense is a little stronger than you might think at first. This, for example, is the precise context of the phrase trial by combat. Criminals hide evidence, not honest people. Over the next 10 days, we will get to see the machines that are crooked, the ballots that are fraudulent, and if we're wrong, we'll be made fools of. But if we're right, a lot of them will go to jail. Let's have trial by combat. I'm willing to stake my reputation. The president is willing to stake his reputation on the fact that we're going to find criminality there. Giuliani's defense is that he clearly said trial by combat in the context of finding fraud later. So what we have is a factual question, and a jury's job is to determine the facts. The factual question is, were his words directed at stopping the certifying of the election with the understanding that this would happen through intimidation? Okay, so because this is a factual matter for a jury, I believe that the motion to dismiss will be denied. Courts don't always do what they should. Sometimes courts get it wrong. I spent a number of years as an appellate lawyer, and courts never got it wrong. I wouldn't have had any work to do. So if a court finds that Giuliani intended to stop the certification and that he understood this would happen through intimidation, his First Amendment defense fails. If his First Amendment defense fails, he's in trouble. He can then be held responsible for any violence that was foreseeable and resulted directly from what the rioters did. If his First Amendment defense fails here, it is also likely to fail in a criminal matter. So let me return to these questions that I started with. How long does justice take? The rule of law is slow and meticulous. Our court system gives the accused the benefit of the doubt. Each motion requires an answer and a ruling. The only way for justice to be quick is in an autocracy. Also, these questions are based on the false idea that the lying of Republicans can be resolved through the legal system. It can't. The legal system isn't designed to solve political problems. Let me give you an example. Suppose Giuliani and Trump are found guilty and put in jail. That will serve justice, but it won't serve the larger political problem. These guys are not going to say, a court found Trump guilty, so I guess we should just break up the party and go home and start playing nice. No, they'll be angrier. They'll call the trial a sham. They'll say the judge was biased. They'll say the jury was made up of Democrats. They'll treat their leaders as victims and martyrs. Now, when I say this kind of thing on social media, people sort of jump on me and say that I'm saying they shouldn't be prosecuted. I'm not saying they shouldn't or won't be prosecuted. I'm saying that won't solve our political problems. I'm saying that the fact that the wheels of justice turn slowly is not the cause of our political problems. The reason democracy is in trouble is because so many people are continuing to vote Republican even after everything we've seen. If the Republicans attracted 25% of the vote, or even 30, 35%, instead of somewhere in the 40s, the Republican Party would shrivel and die. No amount of cheating or gerrymandering would help them because they wouldn't have enough widespread support or political muscle to pull it off. So how do we solve political problems? Well, by citizen involvement, by mobilizing voters. Look at Stacey Abrams. If Georgia turns bluer, it will be because of her efforts. It's a slow uphill battle, and there are no quick, easy solutions. Well, thank you for joining me this week. I'll be back next Sunday with another of these presentations. Again, if you have any ideas or suggestions, leave them for me in the comments, and I'll see you next week. Thank you.